presidential power to the power of parliament or such of the provisions of this constitution shall apply in relation to the state subject to such exceptions and modifications as the president may by order specify.
Yeah.
In other words, the president is given such untrammeled power to specify which are the provisions of the constitution which shall apply to the state of Jammu and Kashmir. That is conditioned by the first proviso and the second proviso.
Right.
But the first proviso and the second proviso don't relate to the substantive provisions of the constitution at all. They only refer to the matters governed in the union list and the concurrent list.
Only the first proviso, not
One second.
Orders, Malak.
Right. You're right.
Yes.
D deals with deals with the presidential order.
First proviso mentions the list, but not the second proviso.
D recognizes as inhering in the president the power to decide which of the substantive provisions of the constitution shall apply to Jammu and Kashmir. Now that power of the president is conditioned by the first and the second proviso.
Yes.
But the first and second proviso to clause D
only provided further that no such order shall relate.
So no such order means the order referred to in the first proviso. And the first proviso only refers to clause 1 of subclause D.
Not these only orders. Yes, it's orders.
I understand that. Yes, clause D. No, 1 second. No, you're not getting the point. The point is this, that D refers to an order which may be passed by the president, making applicable provisions of the constitution to the state of Jammu and Kashmir with adaptations or modifications. Now the question, including the list, now what the first proviso says is that no such order which relates to matters specified in the instrument of accession specified in paragraph 1 of clause B shall be issued except with consultation.
The instrument of accession, Malak.
But that pertains only to the entries in the union list and the concurrent list.
Yes,
absolutely.
Yes,
the face of it.
That's
the second proviso, Malak.
Now the second proviso. Now the second proviso says, provided
other than
that no such order,
which
relates to matters other than those referred to in the last preceding proviso. Therefore,
which includes D, Malak.
No. It refers only, it cannot. I'll tell you why. Provided further that no such order means which order? The order referred to in the first proviso. And the order
mentions order, Manoj.
Sorry?
He also mentions order.
provisos use the word such order.
Such order.
Refers to the order in D. Just 1 minute.
But it is not. D also says the same thing. May order specify. Orders.
I understand that. Yes. Clause D. No, 1 second. No, you're not getting the point. The point is this, that
Orders.
I understand that. Yes. Clause D. No, 1 second. No, you're not getting the point. The point is this, that
Orders.
I understand that. Yes.
That's right. There is different methodology, but Parliament take B.
Lords, Honorable the Chief Justice, in the morning I'd mentioned a matter. There's higher urgency. There are 23 protests going on simultaneously. We have a very volatile situation due to very unfortunate situations that happened in the neighboring state in Haryana and Nu. Now there are 23 protests going on in Delhi.
Have you circulated your email?
Sent it to the...
I'll pass orders immediately.
If your lordships could please...
Of course, that's what the circular says. I'll do that.
Can I hand over hard copies of the IA,
You circulated an email, right? I'll pass orders on.
But the email went to the learned registrar judicial because we couldn't find another email.
He doesn't even allow me to use a washroom. He's waiting just outside to take orders the moment I come to my chamber.
Right. Look, we also circulated to the Honorable Court Master, Your Lordship's Court Master.
Now look at the proviso to clause. Yes.
May I just very simply state what I think is the architecture of 370.
Yes.
Let's go back to it, Mullah. Notwithstanding anything in this constitution, the provisions of Article 238 shall not apply in relation to Jammu and Kashmir. That's done away with now, Mullah, because those are Part A, Part B, Part C, Part D states. Therefore, Mullah, that's over. We're not part of any of those states. The power of Parliament. Now, here, Mullah, it relates to the power of Parliament to make laws. Just kindly note that.
That's the ordinary lawmaking power.
Yes, the ordinary lawmaking power for the state shall be limited. Now, that's important. Even the lawmaking power is limited to those matters in the union list and the concurrent list. Your lordships will see state list is out because residuary power is in the state, which in consultation with the government of the state are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India as the matters with respect to which the Dominion legislature may make laws in that state. So that's that list, Manoj.
We saw the list in the morning.
The list in the morning. So it is only those that Parliament may make laws, but that also with consultation. And consultation is mentioned here itself. Doesn't have to be repeated in the proviso, it's mentioned here itself. Correct? That also has to be consultation. And just let's clarify the architecture. So that's with consultation. Now you come to B. Such other matters, that is again the power of Parliament to make laws. Such other matters in the said list. So apart from the list that are in the instrument of accession, such other matters in the said list.
This list refers to union and concurrent list.
Yes. Only list 1 and 3.
1 and 3.
There. As with the concurrence of the government. So now, Mullahs, that law has to be also with concurrence of the government. So we are dealing only with laws here. Lawmaking power. That's the first, Mullahs, limb of the argument.
That's the restriction on the lawmaking power.
That's the lawmaking power. Concurrence is mentioned here in respect of other matters, Mullahs. No proviso is required. Here, no proviso is required. Now, let's leave the explanation for the moment. The provisions of Article 1 and this article shall apply. See, the provisions of Article 1 and of this article shall apply in relation to that state. So, this is Article 1 and this Art 370. This becomes relevant for D, ultimately. Now come to D. D starts with the word. Now, D doesn't deal with laws. It deals with proclamation and orders of the president. Provisions, such of the other provisions of this. I pause here, mothers. Others excluding 1 and 370. One second, hold on. Let my lords read it. So D is, C says the provisions of Article 1 and of this article shall apply in relation to that state. And D says such of the other provisions, that is excluding 1 and 370, shall apply in relation to that state, subject to such exceptions and modifications as the president may by order specify.
Just 1 minute. C cannot be read in isolation without reading sub clause 1. Notwithstanding anything contained in this constitution,
Correct.
the provisions of Article 1 and this article shall apply in relation to that state.
Correct.
So that means only that Article 1 and this article will apply only in relation to that.
That's all I'm saying, nothing more. Then read D.
Now D, if one reads D.
Such of the other provisions.
Correct.
Which means 1 and 370.
As well as other than the matters in the concurrent and the union list.
That's
correct.
That also.
That also, I agree. And 238 also.
Just 1 minute.
Reading of D is.
Yes.
Brother Khanna's reading is that it will include D, but, sorry, C, but exclude A and B.
Cannot, Mullah.
It will. Otherwise, it will lead
Yeah.
to a situation you are saying that 370 is a permanent article.
Mullah, we'll come to that later whether it's
One minute,
permanent.
yes, that's your argument.
Well, I
370 is
want-
a permanent article which cannot be undone by even with the concurrence.
Let me forget that when I made that argument.
Right now, you're just giving us the structure of the article.
Forget that what I made that argument.
That you're
It
giving
is
us the structure,
temporary.
yes?
It is temporary on 26th of January 1950. Let's forget about anything else. It is temporary. Why? Because, Malaj, the Constituent Assembly may still choose to. So it's temporary. There's nothing wrong with that heading. Let me finish. Let me finish the architecture and then I'll come back. So, Malaj, I was reading such of the other provisions of the Constitution. So that is other than 1 and 370, shall and 238, shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Now you come to orders, not to laws. Provided that no such order. What order? Order under D. Colon. Read the colon, Malaj. Specify colon. Right? Provided that no such order which relates to the matter specified in the instrument of accession, again, Malaj, of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of that state. Again, a colon. Provided further that no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence. You go to B1 and B2. So that was the law, the same template, now the orders for the rest of the provisions. Then read 2, Malaj. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in second proviso to subclause D of that clause be given before the Constituent Assembly for the purpose of framing the constitution of the state is convened, it shall be placed before such assembly for such decision and may be taken thereon. Same template of B and D, Malaj. And they can reject it. They need not confirm it. That's how you retain sovereignty, which is the instrument of accession. And if it don't retain it, it's temporary. That's why temporary. Well, I'm just trying to explain.
With the structure of 370.
Yeah.
You complete clause 3,
Yeah.
then I have one question.
Sure,
But
I'll-
no, but we'll first, you can complete, otherwise I'll be breaking your link. It's on some unrelated area, therefore.
Notwithstanding anything in the foregoing provision. So, Malaj, it's notwithstanding in the beginning of the article. Please note that. Notwithstanding anything in the foregoing provisions of this article, so notwithstanding in 370, the President may by public notification declare that the article shall cease to be operative or shall be operative only with such exceptions and modifications and from such date as he may specify, provided that the recommendation of the Constituent Assembly shall be necessary before the President issues such a notification. So if the Constituent Assembly recommends it, namely, that we want to abrogate 370, then on that recommendation, the President will issue a notification. And this article is contained in subclause 3. Doesn't have to be in D. . So that, according to me, is the architecture of 370.
Now, Sibyl, I have just one question on this. B1 refers to those matters in the instrument of accession which have been ceded by the Maharaja to the Union, the Dominion's power. B2 refers to all other matters in the Union and concurrent list other than what is covered by 1.
Fair enough.
Now, suppose in the area of the Union and the concurrent list, something is not covered by B1 or by B2. In other words, it's not referable to those subjects mentioned in the instrument of accession, and it's not covered by B2 at all. That power is not entrusted to the state.
B2 is all other lists, Mullah.
No. B2 says such other matters in the said list as with the concurrence of the government, the president may order specified.
So all matters in the list.
Right. Of course, it covers. It's a residuary.
Everything.
Yeah. So you have to take the concurrence of the state.
Yes.
Now, suppose it is not covered by B2 in the sense that there is no concurrence of the state. Right? It's not covered by B1.
Yes.
And you have not taken the concurrence of the state under B2.
Correct.
On such an aspect, the state legislature cannot exercise power because it's not in the state list. One second. Nizam, one second.
Residuary power.
One second.
Yeah.
The state legislature, the state legislature is operating on the state list.
And residuary power, Mullah.
Residuary power came in and when? Under what?
Other way around, Mullah.
No,
Kashmir, it was there from the beginning.
Where does the residuary power find?
Yes, I'll show that to you, Lord. This is part of the instrument itself.
Instrument of accession.
Yes, it is part of Mullah's all orders of the government.
No, but has specifically there's
it's also part of the Constitution. I'll show that.
I just wanted to see whether it's part.
Yes. You're always to take it, Mullah.
Because otherwise there'll be a peculiar situation.
Yes.
Where neither parliament can exercise power, nor can the state legislature
I
exercise
take
power.
your lordship's point. I will demonstrate to your lordships that the residuary power was with the state legislature throughout and with the state government throughout. That was the condition on which, Mullah, the accession took place. And I will demonstrate that to your lordship. That's
Mr. Sibyl,
that's
slightly
the least of
different.
my problems.
Mr. Sibyl, slightly different.
Okay. Yes. Yes.
Which is very different from what is subject matter of 1 and 2.
Yes, right.
Because they do not deal with abrogation of the
Absolutely.
article.
Absolutely.
Right.
Yes, absolutely. Your lordship is right.
And therefore, when we read at that power, which is specifically conferred on the president,
Yes.
then proviso, leave aside for the time being the proviso. Do you agree with that interpretation?
No, I
Or
don't.
for the time being, just leave the proviso.
Well, I can't read the Constitution in this fashion. I can't even read an act in that fashion. Let's forget the Constitution. How do I leave the proviso when the Constitution is staring us in the face?
No. The question
Your
was,
lordship is putting to me.
therefore, clause 3 deals with abrogation of the article itself, which is not the subject matter of 1 and 2.
No, it's subject matter of C. Article 1 shall apply to the state.
No, correct. But it deals with complete abrogation of the article itself.
I agree.
And in that context, you may argue that your argument at the first fold was, it will be only if the conditions of the proviso is satisfied, that clause 3 will apply. Otherwise, if the conditions of the
That's how
proviso
your
are not
lordships have
satisfied,
interpreted it.
clause 3 will not
That's
apply.
how your lordships have interpreted proviso since 1950, Mullah. That's all that I can say. I can't say more than that.
A proviso may in some cases be an exception. A proviso may in some cases be an elaboration.
There's a
or-
difference, Mullah. Yes.
It depends upon the nature of the.
The
Provisos are sometimes change
That's
colors.
proviso, Mullah. Proviso that the recommendation,
Rule for a proviso in that sense.
provided that the recommendation of the legislative, of the Constituent Assembly shall be necessary. It's a restriction on the exercise of power. That's right, referred to in clause 2, Mullah.
Quick way to interpret clause 3 to say that the power existed and then will vanish once the Constitutional Assembly of the state is no longer exists.
But you kindly read 2, Mullah. if the concurrence of the government of the state referred to in para 2, subclause B or 1 of the second proviso to D of that clause be given before the Constituent Assembly for the purpose of framing of the Constitution that's the purpose.
Mr. Sibal, you have contradicted yourself. When you refer to clause C, subclause C is an independent clause and clause D not applicable to clause C.
No,
Then
what
the
I'm
second
saying is,
proviso will not apply.
in both cases,
And therefore only subclause 3 will apply.
Himala's point is clause 2 says that
Clause 3 will apply.
even for the purposes of those notifications.
Anyway, we'll examine that.
Yes.
We have understood your line of argument.
No, there is something that's missing, Malas. The proviso says, provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Why are they saying that, Malas? The purpose is given in clause 2. Provided that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary for the president before the president issues such a notification. It is necessary and before he issues it. How can you say that it's explanatory or that it's an independent clause? It specifies how it is to happen. It has to happen before. That is, the permission has to have before.
You know, the reason why clause 3 refers to the Constituent Assembly of the state referred to in clause 2 is because clause 2 refers to the Constituent Assembly for the purpose of framing the Constitution.
That's correct. That's exactly
Right?
why
That's your point. You get that point?
Yeah.
Now, therefore, the recommendation of which Constituent Assembly, this makes it very clear that one and only Constituent Assembly which was formed for the purpose of framing of the state constitution.
Right.
Once the frame of the constitution was done, then that purpose of the Constituent Assembly is not like a permanent body. Like Parliament is a permanent body. The Supreme Court is a permanent body.
No doubt about it.
It's a body which has a specific purpose and then after it becomes functus officio, so to speak.
Right.
Therefore, once the Constituent Assembly had fulfilled its purpose, then the proviso itself has no application.
No, this is the problem, Malaj, with the problem there is when you are applying 3 without the proviso and saying this is a blanket power, then Malaj, the president can do it anytime without any consultation with anybody.
Sibal, one thing which we must
just passes an order.
Mr.
That I
Sibal,
integrate. That's
one thing which we have to also bear in mind is all these provisions are in Part 21. Part 21 has used 3 expressions: temporary, transitional, and special.
correct.
Temporary provisions are those which are intended to be in existence for a limited period of time,
That's right.
but without a point of terminus, right? A temporary government servant. That person is temporary
Sure.
for a limited period of time,
Right.
but whose services are to be terminated. Until you are terminating the services of that person still continues.
Right.
That's that broad concept, of temporary.
Absolutely right.
Transitional means something which necessarily has a terminus.
That's right.
That it
Laws
comes to
made
an-
earlier.
I'll show you some of the transitional provisions in this part.
Right.
And third is special.
Right.
Now we'll see, for instance, after 370, we'll get some idea from the provisions after 370. Say 371, special provision with respect to Maharashtra and Gujarat. 371A, special provision for Nagaland.
Yes.
Then we get 371B, special provision for Assam.
Correct.
371C, special provision for Manipur.
That's correct.
D, for the state of Andhra Pradesh and Telangana.
Right.
E, establishment of Central University in AP. F is special provision for Sikkim, which came in 75.
Right.
G, Mizoram. H, special provision for Arunachal.
Yes.
Then I for state of Goa. J for the state of Karnataka.
Right.
Now, after these special provisions end, we come to 372,
Right.
which continuance in force of
Existing laws.
existing laws,
Yes.
which then says, shall continue in force until altered or repealed or amended by a competent legislature
Right.
or by any other, like the penal code.
Right.
It just continued in force until it is altered. Then similarly, now we have 372A, power of the president to adapt laws.
Right.
And it says the president may by order made before the 1st of November 1957 make such adaptations and modifications.
Right.
So this was a transitional provision that the president had to make those adaptations by the 1st of November 1957. So it was a transitional provision. After that, the power lapses. So similarly, 373, was then came the provisions relating to the judges whose services had to be taken over by the Union of India, public service commissions, so on and so forth. And then 392, the power of the president to remove difficulties.
Right.
So therefore, part 21 basically covers special provisions, temporary provisions, and transitional provisions.
Right.
Now, it doesn't use the expression transitional in any head note or marginal note to the articles. But temporary and special are used in the marginal notes to specific articles of part 21. And 370 specifically uses the expression temporary.
It had to, Malad. It had to.
So, can we then, by saying that the power under clause 3 goes once the Constituent Assembly comes to an end, really convert this into a permanent provision, which it was never intended to be by the Constitution?
But that's one, your lordships are now putting to me, it was never intended to be. In 370, when it was put in, it had to be a temporary provision. It had to be, Malad. There was nothing there at that point in time. It had to be, Malad. It could never be a permanent thing.
So why did the Constitution then put it in part 21?
Because, Malad, it is a separate, it relates to a particular state where the two sovereigns have come together and made a compact which is incorporated and integrated.
No, part 21 does not deal only with Kashmir. Doesn't deal only with Jammu and Kashmir. It deals with other states.
I'm sorry, I didn't get it.
Part 21
Yes.
does not deal only with Jammu and Kashmir.
No, of course not. That's why I think it's a separate, independent provision and has to be interpreted on its own terms. You can't incorporate Muller's concepts outside of 370 and integrate them into 370 and say, this is how we'll read 370. Yes. 370 is not temporary. 370 is not temporary.
The note expressly says it's temporary.
No, it says temporary provisions with respect to temporary provisions. In other words, this is a provision which is temporary till such time as the Constituent Assembly decides this way or that way. That's the whole purpose, Mullahs. Because when the Constitution came into force, there was no such thing as the Constituent Assembly even. How did the Constitution add this here? Because there was an understanding. Otherwise, why would you bring in the term Constituent Assembly in 370? It was not anywhere else. Temporary, supposing, not that I should say so, one never knows. Supposing the Constituent Assembly decided not to be with India, then what happens? We would have to do what we did to Junagadh.
There are two types of temporary provisions in part 21. One type is Article 369. 369 says Parliament had the power to make laws for a period of 5 years.
That's correct.
On certain matters, even if they may not be in the concurrent.
Absolutely, yes.
So they were temporary with reference to time. They were temporal.
I agree.
Then 370 is an illustration of a case which is temporary in the sense it will operate till abrogated. Would it be? I mean, we're just when Mr.
Not till abrogated.
When we are putting your point, it's actually we are thinking.
I understand.
We are just.
I understand. This is your lordships have always done this, Your lordship. This is a very fruitful debate because we all have to understand. We are here standing
and it's only
for
in that
India.
process that
We're
we can
really. For
really.
the people of India, we're not. This is not something that we believe we are totally integrated into India. That's not an issue, We are. We have said so. Therefore, there is no. As far as. I mean, our constitution says we're an integral part of India. So where's the question of moving away from that? Yes, yes. Yes. Yeah. Yeah. There were only two choices, Marat. We said, the Constituency Assembly said all of Constitution to apply. We'd be like any other state.
But they don't have to make a constitution of their own.
Then they don't have to make a constitution of their own.
Indian constitution applies.
Once again, they don't have to make a constitution of their own. The Constituent Assembly would say, we integrate into India, we're part of India, we're like any other state, we don't need a constitution, and all those lists will apply. That power is there. So why was it called a temporary provision? Because that had to be decided by the Constituent Assembly. And then you interpret the terms to find out how that power is to be exercised. Because it was unlike any other state. The residuary power was always with the state. In the Delhi Agreement in 1952, I have a reached.
370 came in with the original constitution.
Yes.
But is there anything in the Constituent Assembly debates which throws
Yes.
lights on why they introduced it?
I'll do that straight away. Yes, I'll give your lordships that. Exactly what I'm saying is what they said.
Let us see the CAD.
Volume 8.
Volume 8.
Now.
This volume 8, huh? Yeah. Originally, I kindly see volume 8, PDF page 1173. It's okay, 1174 actually. Volume 8, PDF page 1174.
1174.
PDF one.
PDF 1174.
Volume
4034.
Running page 4035.
4035.
Yes, running page. But PDF 1174.
Volume 8.
Volume 8. By now we know your lordships elicit answers in order to find out what we wish to say. Not that your lordships have ever decided on one way or the other. We always do that, and I've seen
Till the
this
last
happening
word is
before.
said in a matter,
Yes,
Mr.
exactly.
Sibal, everything is open.
When the printed word comes, that's the last word.
Yes, I always felt Mr. Sibal as the judge is very quiet, there is a problem.
That's a real problem. It's a real problem, which we face
Actually, Mr.
occasionally.
Sibal, there are times when you start dictating a judgment, you start dictating it with a certain...
And then you change your mind.
And you start dictating with a certain conclusion in mind,
I see.
because that's what you have formed. When you start dictating it,
Yes, yes.
then you realize that your line of reasoning is wrong, because, when you dictate, the logical syntax has to fall in place when, you are engaged with yourself. Then you realize, no, it's not going to fit in like this.
Quite frankly, Millard, and I'll be honest, when I looked at it myself, I asked this question that your lordships is asking me. I must ask that question.
4034, Mr.
Yes, 4035.
Oh, sorry, 1174,
Yes, 1174. Then kindly come to Millard, the sentence starting. Sir, this matter, your lordship has that? They set out Millard.
Gopal Swami Iyengar?
Yes, I am. Gopal Swami.
Yes.
Then it says, sir, this matter, the matter of this particular motion relates to Jammu and Kashmir. The House is fully aware of the fact that the state has acceded to the dominion of India. The history of this accession is also well known. The accession took place on 26th October 1947. Since then, the state had a checkered history. Conditions are yet not normal. The meaning of this accession is that at present the state is a unit of a federal state, namely the Dominion of India. This Dominion is getting transformed into a republic, which will be inaugurated on 26 January 1950. The Jammu and Kashmir state, therefore, has to become a unit of the new Republic of India. As the House is aware, accession to the Dominion always took place by means of an instrument which had to be signed by the ruler of the state and which had to be accepted by the Governor General of India. That has taken place in this case. As the House is also aware, instruments of accession are a thing of the past in the new constitution, will be a thing of the past in the new constitution. The states have been integrated with the Federal Republic in such manner that they do not have to exceed or execute a document of accession for the purpose of becoming units of the Republic, but they are mentioned in the constitution itself. And in the case of practically all states other than the state of Jammu and Kashmir, their constitutions also have been embodied in the constitution for the whole of India. And all those other states have agreed to integrate themselves in that way and accept the constitution provided. The discrimination is due to the special, why this discrimination? That's the question asked. The discrimination is due to the special conditions of Kashmir. That particular state is not yet ripe for this kind of integration. It is the hope of everybody here that in due course, even Jammu and Kashmir will become ripe for the same sort of integration as has taken place in the case of other states. At present, it is not possible to achieve that integration. There are various reasons why this is not possible. Now, I shall refer again to this a little later. In the case of other Indian states or unions of states, there are 2 or 3 points which have got to be remembered. They've all accepted the constitution framed for states in part 1 of the new constitution. And those provisions have been adapted so as to suit conditions of Indian states and union of states. Secondly, the center, that is the Republican Federal Center, will have power to make laws applying in every such state or union to all unions and concurrent subjects. Thirdly, a uniformity of relationship has been established between those states and unions and the center. Kashmir's conditions are, as I have said, special and require special treatment. I do not want to take much time of the House, but I shall briefly indicate the special conditions are. In the first place, there has been a war going on within the limits of Jammu and Kashmir. There was a ceasefire agreed to at the beginning of this year, and that ceasefire is still on, but the conditions in the state are still unusual and abnormal. They've not settled down. It is therefore necessary that the administration of the state should be geared to these unusual conditions until normal life is restored. Part of the state is still in the hands of rebels. We are entangled with the United Nations in regard to Jammu and Kashmir, and it is not possible to say now when we shall be free from this entanglement. That can take place only when Kashmir problem is satisfactorily settled. Again, the government of India have committed themselves to the people of Kashmir in certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the Republic or wish to go out of it. We are also committed to ascertaining the will of the people by means of a plebiscite, provided that peaceful and normal conditions are restored and the impartiality of the plebiscite. This is not relevant anymore.
Next sentence. Next sentence.
Next sentence, but this is not relevant. Plebiscite issue is not relevant.
Part is not relevant as per your argument. Even the part before that.
Yes, now see further, Malad. We have also agreed that the will of the people, through the instrument of a constituent assembly, will determine the constitution of the state as well as the sphere of union jurisdiction of the state. That's why it was a temporary provision. Now, next paragraph. At present, the legislature, which was known as the Praja Sabha in the state, is dead. Neither that legislature nor a constituent assembly can be convoked or can function until complete peace comes to prevail in the state. We've therefore to deal with the government of the state, which, as represented in its council of ministers, reflects the opinion of the largest political party in the state. Till a constituent assembly comes into being, only an interim arrangement is possible, which is why it is temporary, and not an arrangement which could at once be brought into line with the arrangement that exists in the case of other states. This tells your lordships why it is temporary. Now, if you remember the viewpoints that I have mentioned, it is inevitable conclusion that at the present moment we could establish only an interim system. Article 306A as, now what is 306A? 370. is an attempt to establish such a system. Interim till the Constituent Assembly decides. I shall now to proceed, Madam, that's not relevant. So clearly, Madam, clearly, it gives you an indication why it was interim. It gives you an indication why it was temporary. Because there was nothing in place. Legislature was not working, Constituent Assembly was not in place, and the will of the people had to be taken, which was reflected in the Constituent Assembly. Therefore, it was temporary. And therefore, 370, Madam, now remember this, when 370 is enacted in 1950, at that point in time, nothing is in place. And yet in 373, they say, you will have to get the recommendation of the Constituent Assembly. That is, dehors the Constituent Assembly having been formed. Dehors its constitution. Why would the Constitution say that? Then kindly come to 4039. Second paragraph of 4039. Yes, that's. Now it's very interesting, Madam. Well, let's read the paragraph, then we come to clause 2. First that, and then I'll read the other paragraph. Then we come to clause 2. My lords have that? That's PDF 1178. 4039. That's right.
Justice called them.
No, Malas, actually,
Justice called them.
maybe Malas, I should start with
Volume eight.
volume 8, 1176. Let's take 1176. PDF 1176. Turning page 4037.
Then read the whole thing. You might be
Yeah, I'll read the whole thing.
because it will be the interpretation they asked you before lunch.
Malas, most of your lordship's questions, Malas, hopefully are answered in this. There's the second portion of this article, 1076, Malas.
He hasn't got it.
Yes. He says, Malas, I shall now proceed to, your lordship has that paragraph? I shall now proceed to take the House through the provisions of this article. That's 306A, which is 370. As honorable members will remember, the Constitution of Indian states is mainly governed by Article 211A of this Constitution, which applies to the Constitution to Indian states, the Constitution of Indian states, subject to the modifications contained in Part 6A, read with the schedule. So far as that provision is concerned, I've already indicated to you that the provisions regarding the Constitution of other states could not at present be applied to Jammu and Kashmir. Therefore, Clause 1 of A of this article says that the provisions of 211A of his Constitution shall not apply to the state of Jammu and Kashmir. That's 238, Malas. 211A is 238A.
Now B.
The second portion of this article relates to the legislative authority of Parliament. So Parliament may by law. That's B. Over the state of Jammu and Kashmir. This is governed primarily by the instrument of accession. Broadly speaking, that legislative power is confined to the three subjects of defense, foreign affairs, and communications. But as a matter of fact, these broad categories include a number of items which are listed in the instrument of accession. I believe they include, I believe they number some 20 to 25. Now, these items have undergone a change in description, in numbering, in arrangement, as amongst themselves in List 1 and List 3 of the new Constitution. It is therefore necessary that the items mentioned in the instrument of accession should be brought in line with the changed designations of entries in the lists 1 and 3 of the new Constitution. So, Clause 1B of 306A says that this listing of items as per the terms of the new Constitution should be done by the President in consultation with the government of the state. That explains, Manoj. B1. Clause B2 refers to possible additions to the list in the instrument of accession. And these additions could be made according to the provisions of this article with the concurrence of the government of the state. The idea is that even before the Constituent Assembly meets, it may be necessary in the interest of both the center and the state that certain items which are not included in the instrument of accession would be appropriately added to the list in that instrument so that administration, legislation, and executive action might be furthered. And as this may happen before the Constituent Assembly meets, the only authority from whom we can get consent for the addition in the government of the state, that is provided. Then there is the explanation, which defines what the government of the state means. The government of the state is defined both in the Constitution, which is now supposed to be in the force in Jammu and Kashmir, the state, as well as the proclamation with the Maharaja issued on 5th March 1948, the terms of which are as follows. Then kindly come to C and D. Yes, second last paragraph in 1177, PDF 1177. 4038. My lord has that. Clause C and D refer to the provisions of the Constitution other than matters listed in 1 and 3. These various provisions have been divided into certain categories. The first, according to this draft, is that Article 1 of the Constitution will automatically apply. As you know, it describes the territory of India and includes among those territories all the states mentioned in Part 3, and Jammu and Kashmir is one of the states mentioned in Part 3. With regard to the other provisions in the Constitution, these will apply to the Jammu and Kashmir state with such exceptions and modifications as may be decided on when the President issues an order to that effect. The order can be issued...
Just read the sentence once again. With regard to other provisions of the Constitution,
Yes,
these will apply when the President issues an order to that effect.
yes,
That order can be issued with regard to subjects mentioned in the instrument of accession only after consultation with the government of the
Yes.
state.
yes.
With
Correct.
regard to other matters, concurrence of the government has to be taken.
That's B1 and B2, Madam. Two provisos, B1 and B2. That order can be issued in regard to subjects mentioned in the instrument only after consultation. In regard to the others, it concurs. Now, it is not the case, nor is it the contention of the members of Kashmir government, whom I took opportunity of consulting before this draft was finalized. It's not their intention that the other provisions of the case.
No.
Sorry. That's right. Now, it is not the case, nor is it the intention of the members of the Kashmir government, whom I took the opportunity of consulting before this draft was finalized. It's not their intention that the other provisions of the Constitution are not to apply. That particular point of view is that these provisions would apply only in cases where they can suitably apply and only subject to such modifications or exceptions as the particular conditions of Jammu and Kashmir may require. I wish to say that no more about that particular point at the present moment. Then we come to clause 2. You will remember that several of these clauses provide for concurrence of the government of Jammu and Kashmir state. Now, these relate particularly to matters not mentioned in the instrument of accession. And it is one of our commitments to the people and government of Kashmir that no such additions should be made except with the consent of the Constituent Assembly, which may be called in the state for the purpose of framing its constitution. In other words, what we are committed to is that these additions are matters for determination by the Constituent Assembly of the state. This is commitment. Now you will recall that in some of the clauses of this article, we have provided for concurrence of the government of the state. The government of the state feel that in view of the commitments already entered between the state and the center, they cannot be regarded as final authorities for the giving of this concurrence, though they are prepared to give it in the interim periods. But if they do not give this concurrence, this clause, if they do give this concurrence, the clause provides that that concurrence should be placed before the Constituent Assembly when it meets, and the Constituent Assembly will take whatever decisions it likes to take. What can be clearer than this? The last clause refers to what may happen later on, which is why it's temporary.
So the paragraph which you read is with reference to clause 2, not with reference to clause 3.
Yes, I'm not saying that. I am just reading.
The last clause is clause 3.
I'm saying, I'm reading it holistically so you know why it is called temporary.
2 and 3 are temporary.
2 and 3 are temporary, no doubt about it, because they have to be actually agreed upon by the legislature, by the Constituent Assembly. Now C3. The last clause refers to what may happen later on. We have said Article 211A, which is 238A, will not apply to Jammu and Kashmir, but that cannot be a permanent feature of the Constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met and taken its decision, both on the Constitution for that state and on the range of federal jurisdiction over the state, the President may, on the recommendation of the Constituent Assembly, issue an order that this Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. But before he issues any order of that kind, the recommendation of the Constituent Assembly will be a condition precedent. That explains the whole of the article. Well, there can be nothing clearer than this. I mean, we in hindsight, sitting in 2023, can't interpret a provision except on its terms. We're here to interpret the Constitution. We're not here to legitimize a process which is inconsistent with the express terms of the Constitution. Next paragraph. The effect of this article is that the Jammu and Kashmir state, which is now a part of India, will continue to be a part of India, will be a unit of the future Federal Republic of India, and the Union legislature will get jurisdiction to enact laws on matters specified either in the instrument of accession or by later addition with the concurrence of the government of the state, and steps have to be taken for the purpose of convening a Constituent Assembly in due course, which will go into the matters I have already referred to. When it comes to a decision on the different matters, it will make a recommendation to the President, who will either abrogate 306A or direct that it shall apply with such modifications and exceptions that the Constituent Assembly may recommend. That, sir, is briefly a description of the effect of this article, and I hope the House will carry it. This explains several things. One, why it was a temporary provision. Two, Constituent Assembly had not been constituted then. It was envisaged in our Constitution that it will be constituted. And the ultimate authority of abrogating 370 will be left to the Constituent Assembly. And a precondition of that would be a recommendation of the Constituent Assembly for the President to pass on. Absent that, it can't be done. That was the understanding of the lawmakers, of the Constitution makers of India, of the Constituent Assembly. That is why it was put in. It was not a temporary provision in the sense that it had ultimately 370 had to be abrogated. That's not the meaning of the temporary provision that we're talking about. In any case, Malaj, a heading of an article can determine the content of the article. Content of the article is clear. So, Malas, the government of the day was staring at the provisions of Article 370. And according to me, through a political act, not a constitutional procedure, declared that 370 is gone. That's why I said it was tossed out of the window through a political act, not through a constitutional act. Such a political act cannot be determined by the Parliament of India. It's not in the remit of the Parliament of India to take a political decision to abrogate 370. And I will demonstrate as we move along, Malas, how it was done and in what manner it was done. Nobody can deny that the people of Jammu and Kashmir are with the Union. It's an integral part. Nobody can deny that. But there is a special relationship. There is a unique relationship which is engrafted in 370 itself. You can't jettison that except by following a process which is ordained by law. So, as your lordships asked me on the Constitution, I wanted to just mention this. This is the debate. Amarat.
One second. We shouldn't teach that.
And then I just want to mention that all the amendments sought, Malas, were all rejected and withdrawn,
Not moved.
not moved.
Mr. Mahaviragi, he did not move those amendments.
Yes. Sir. So, Malas, may I go back to the list of dates now? Now that I've, Malas, put my position on Article 370 straight away. Well, let's go back to the list of dates, Malas, and finish. Malas, kindly come to my written submissions, volume 2. and the PDF page is 41. Same page that I left.
You are on the list of dates and the serial where you left.
Yes, ma'am, that's right. The report, unless we have a clear picture of 370, but it will be difficult to. Item 33 at page PDF 41. My lords have that? Justice. So you can't.
Yes.
Under 370 sub-article 1 of the Constitution and following consultation with the government of Jammu and Kashmir, the President issued the Constitution application of Jammu Kashmir Amendment Order 39, modifying Articles 54, 55 of the Constitution, as long as they applied to state of Jammu and Kashmir. Now, as your lordship will notice, each of these orders were issued under B1. D1, all of these orders.
B1,
D1,
D1.
all of these orders. Then in 1952, on the 10th of June, whereas on June 10, 52, the basic principles of Committee of Jammu and Kashmir Constituent Assembly submitted its interim report to the Jammu and Kashmir Constituent Assembly and recommended that the form of the future constitution of Jammu and Kashmir shall be wholly democratic. The institution of hereditary rulership shall be terminated. The office of the head of state shall be elective. Then the next is very important. In 1952, the Delhi Agreement of 1952 was entered into between the Government of India and the Government of Jammu and Kashmir. Under this agreement, the Government of India agreed that while residuary powers of the legislature vested in Parliament in respect of other states, in the case of Jammu and Kashmir, such powers vested in the state itself. This is what my lord asked me the question. Now, let us kindly read this document. It's very important. Volume 1 of the compilation of documents, pages 13, PDF 13. 1 second. Yes. 1 second. Worship has that? The Delhi Agreement, 1952. Surikant has that. This is Malad's
Page?
page 13, PDF 13.
This doesn't seem to be the main
one.
agreement. This seems to be some summary of the features of the agreement.
Yes, yes.
It's a summary of what I perceive.
What happened, what the features are.
Where is this summary taken from? Because the authenticity will depend on that.
The very next page is there, Madad, I believe. This is Sheikh Mohammed Abdullah's statement to the Constituent Assembly on the Delhi Agreement on 11th August 1952. That's at PDF 16.
That's the actual extract.
Yes, I can read that, Madad. I can read that. That's not the original either. I'll get you the original, Madad. They'll have it in any case. What? Yes. That's the extract from the original. Are you sure? What is that page? 13 is an extract of the original. Summary of
Summary, actually.
Main features of this agreement.
Page 16 is the extract. Page 16.
Page
PDF.
16 is actually just is a Sheikh Mohammed Abdullah's statement to the Constituent
Extract
Assembly.
of the statement to us. Yeah.
Yes.
Can I read the summary, Mother? That this is not something that will be
You want to read the summary?
controverted seriously. Says that in view of the uniform and consistent stand taken by the Jammu and Kashmir Constituent Assembly, the sovereignty in all matters other than those specified in the instrument of accession continues to reside in the state. The Government of India agreed that while the residuary powers of the legislature vested in the centre in respect of all states other than Jammu and Kashmir, In the case of the latter, they vested in the state itself. It was agreed between the two governments that in accordance with Article 5 of the Indian Constitution, persons who have their domicile, we're not concerned with so much with the domicile issue. And I can read it. That the two governments that in accordance with Article 5, persons who have their domicile in Jammu and Kashmir shall be regarded as citizens of India.
State subject, Sybil, may not be directly relevant.
That's why I said, Malad. Then, Malad, 4 is the union government agreed that the state should have its own flag in addition to the union flag. But it was agreed that the state government, that the state flag would not be a rival to the union. It was also recognized the union. Leave that out.
How Sadar Riyasat has to be.
Yeah, that's right. That also. Then small Roman 6.
Yeah.
With regard to the fundamental rights, some basic principles agreed between the parties were enunciated. It was accepted that the people of the states were to have their fundamental rights. But in view of the peculiar position in which the state was placed, the whole chapter relating to fundamental rights of the Indian Constitution could not be made applicable to the state. The question which remained to be determined was whether the chapter on fundamental rights should form a part of the state constitution of the Constitution of India as applicable to the state. So it was not much applied at that time, fully. With regard to the jurisdiction, they'll leave that out on the Supreme Court. And then, there was a great deal of discussion, item 8. With regard to the emergency powers, the government of India insisted on the application of Article 352, empowering the president to proclaim a general emergency in the state. State government argued that in the exercise of its powers over defense, item 1 of the union list, in the event of war or external aggression, the government would have full authority to take steps and proclaim emergency. But the state delegation was, however, averse to president exercising the power to proclaim a general emergency on account of internal disturbance, which ultimately your lordship knows was also taken out of the Indian Constitution under 352.
At the relevant time, it was there.
It was there at the relevant time, but the state said we will not allow it to be exercised.
I'm just trying to think aloud. At the relevant time in 75.
Yes, it was there.
It was there.
It was very much there.
And this, through some subsequent orders, it equally applied to Jammu Kashmir at that time.
That's correct. That's correct. Absolutely right.
This summary which my friend was doing, Delhi Agreement summary, this seems to have been taken out of this book, and Justice A.S. Anand.
It's not publicly available, but Justice Anand has that one.
Constitution, it's published. Constitution
No.
Jammu and Kashmir.
The agreement is not publicly available.
So he has given the authoritative statement in the sense, what is it? What does it imply?
That's correct. This is also part of the compilation, which is before your law.
Yes.
Justice
That's what we
Anand
were reading.
Yes. 10 minutes. In order to meet the viewpoint of the state delegation, Government of India agreed to the modification of 352 in its application to Kashmir by the addition of the following words, but in regard to internal disturbance of the request or with the concurrence of the government of the state. That's how. But the parties agreed that the application of 356, dealing with suspension of the state constitution, and 360, dealing with financial emergency, was not necessary. Right. Then Millet's Sheikh Abdullah's statement to the Constituent Assembly on 11th August. I crave permission to make a statement before the House in regard to the constitutional relationship with Jammu Kashmir and the Indian Union. As the honorable members are aware, during the last session of the Constituent Assembly, the Basic Principles Committee had submitted a report making certain specific recommendations about the future head of the state. House, while accepting these recommendations, had charged the drafting committee to present for the consideration of the Assembly a draft resolution incorporating the proposed principles for the election of the head of state. Drafting committee will no doubt submit its report to the House. Since the changes proposed in the Assembly involve corresponding adjustments in the Indian Constitution, Government of India desired that it should have time to discuss with our representatives other matters pertaining to the constitutional relationship of our state with the Union. During the last stage of these discussions, it became necessary for me and some of my other colleagues in the government to participate in the talks. I'm now in a position to inform the House that certain broad principles have been laid down and certain decisions have been tentatively arrived at between the two governments. The basis of our relationship with India is the instrument of accession, which enabled our state to enter into a union with India In accordance with the terms of the instrument, certain powers were transferred to the center. The principal matters specified with the purpose in respect to which the Dominion legislature could make laws for the state were. This arrangement involved a division of sovereignty, which is the normal feature of a federation. Beyond the powers transferred by it to the union, the state enjoyed complete residuary sovereignty. That's why, Malas, when you read 370, you can't read into it, Malas, other matters. But these terms of the association of our state with the Dominion were maintained, and subsequently, when the Constituent Assembly of India was charged with the task of framing a constitution, this overriding consideration was kept in view in determining the position of this state in the proposed constitution. Earlier to this, it had been agreed between the two governments that in view of the special problems arising in respect of this state and the fact that the government of India have assured its people they would themselves finally determine their political future, a special position should be accorded to Jammu and Kashmir in the future constitution so that a limited field of the union powers over the state is ensured. Our representatives were nominated by the Jammu and Kashmir state to the Constituent Assembly of India. These representatives participated in the deliberations of the Assembly in India at a time when the bulk of the Indian constitution had already been adopted. It was at this stage that the constitutional position of this state was determined in the Constitution of India. This is very important. It was a collaborative exercise, a dialogue. It was not behind the back of the Union of India or anything like that. They knew what was to happen in the future. Representatives of Jammu and Kashmir reiterated their view that our association with India should be based on the terms of the instrument of accession. It was at this stage that the constitutional position was determined. The representatives of the Jammu Kashmir state reiterated their view that an association with India should be based on the terms of the instrument of accession. It was also made clear that while the accession of Jammu and Kashmir state with India was complete, in fact, and law, to the extent of the subjects enumerated in this instrument, the autonomy of the state with regard to all other subjects outside the ambit of the instrument of accession should be preserved. It means a good deal of confused thinking and uninformed criticism is indulged in some interested people. I would like to point out that the Constitution has confined the scope and jurisdiction of the Union powers to the terms of the instrument of accession, with a proviso that they may be extended to such other matters as the President may by order specify with the concurrence of the Jammu and Kashmir Assembly. This is the concurrent list matters. The special problems facing the state were thus taken into account, and under the Constitution, the relationship approximated to that subsisting under the instrument of accession. The Constitution of India, of the Indian Union, therefore clearly envisaged the convening of a Constituent Assembly for the Jammu and Kashmir state, which would be the accession on which this article is based. We've always held that the ultimate source of sovereignty resides in the people. It is therefore from the people that all powers can flow. Under these circumstances, it is up to the people of Kashmir through this assembly to transfer more powers of mutual advantage to the custody of the Union. So what happens ultimately, and I'm just, since I will come to that later, is that Parliament exercised the will of the people of Jammu and Kashmir when they abrogated the article. That's what happened. They took upon themselves the constitutional responsibility of saying that we are now the legislature. We are the Constituent Assembly. And we will exercise the will of the people of state of Jammu and Kashmir to say that we abrogate 370. In essence, that's what happened. Is that possible constitutionally? Is that envisaged by 370? Is this not an exercise of political power? Without reference to 370? And can such a power be exercised in the manner in which it was exercised? That's a matter of procedure. Well, then there is citizenship. We need not go into it. Fundamental rights. We don't have to go into all this. Well, let's now kindly come to list of dates again. Right, back at 42 months. Item 37. Article 370, sub-article 3. The PDF, Madam, 42. My Lord Justice, do I have it?
Yes, 37.
Yes. Under. I just was wondering whether all of your lordships have it.
Yeah, pretty much other-
I have to say, Madam, that I've been and even though I say it to myself, a good student because I can access it immediately.
This is my second constitution where
Oh, I
I see
see.
the Chief Justice who's made me take to this.
No, Madam, I learned
More
my lesson when
adapted
my
than
Lord
thought.
said to me, I'm not going to allow you to argue on your. So I had to learn.
Yes.
37 minutes. Under Article 370, sub-Article 3 of the Constitution, the President, after a recommendation of the J&K Assembly, issued Notification 44, modifying 370, to include an explanation that the phrase state government meant the Sadr-e Riyasat acting in aid and advice of the Council. Kindly note that. That was done by the Constituent Assembly. That's the only time others they exercise their powers. With reference to 370. On 14th of May 1954, with the concurrence of the government of Jammu and Kashmir, the President issued the Constitution adaptation to Jammu Kashmir Order 1954, which came into force on May 14, 1954. This order superseded the Constitution application to Jammu Kashmir Order of 1950, which had only those limited provisions. Paragraph 2 of the said order set those provisions of the Constitution, which in addition to Articles 1 and 370, because that order only had Articles 1 and 370, would be applicable, and other than one, would be applicable to the state of Jammu and Kashmir. Notably, a second proviso was introduced into Article 3 as applied to the state of Jammu and Kashmir in the following terms, provided that no bill providing for increasing or diminishing the area, this is also very important, of the state of Jammu Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. So your Lordship knows, Mullahs, Article 3, they can change the boundaries. What happened in this case was, not that they changed the boundaries, Mullahs, they converted it into a union territory, which is the other problematic issue, which of course we'll have to argue later. You can change the boundaries of a state, you can bifurcate the boundaries of a large state into smaller states, but never in the history of this country has a state been converted into a union territory.
You can carve out a union territory out of a
You
state.
can carve out, but you can't have all of Madhya Pradesh being a union territory tomorrow.
Understanding some assurance that on assembly elections being held, Jammu and Kashmir will be a state. Or I
No,
read it
that's
somewhere.
true, but what they have converted it into a union territory as of now. I mean, that's unthinkable. And under the article for Jammu and Kashmir, there was a special provision that had to be consented to. That was also not done. So, Malas, you move away from representative democracy, convert it into a union territory under your direct rule. You do away with representative democracy, and 5 years have passed. Every day we hear that we are going to soon have elections. But there has to be a constitutional basis for doing this, Malas. And kindly note one thing. In May 2019, there were parliamentary elections in the state of Jammu and Kashmir. In 2019, May, 3 months after this. This happened on the 6th of August, September, October, November, December, May. You have parliamentary elections. So you can hold parliamentary elections, but you will not hold state elections. But I'm moving away from that to another issue altogether. So, Malaj, then 1039, 1711-1956, the Constituent Assembly of Jammu and Kashmir, in exercise of its constituent powers, approved and adopted the Constitution of Jammu and Kashmir. Which is why I started off with the proposition that the concept of a Constituent Assembly is a political exercise. That political authority, that political body can decide on the future of the state. Could have decided on the future of the state. But that's a political decision. You want to abrogate 370, abrogate 370. You want to go integrate into India completely, say we don't need a constitution. But that's a political act. That political act cannot be exercised by parliament, by a legislative body. Because that legislative body is controlled by the Constitution, and its functions are controlled by the Constitution. It can't go beyond that. Which is why I made that statement at the beginning. Then verse 40, the Constitution of Jammu and Kashmir 1957 came into force on January 26, 1957. By means of this constitution, the people of the state of Jammu and Kashmir, having solemnly resolved in the presence of the accession of this state of India, which took place on 26th day of October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof. That's declared in the Constitution. So nobody can question that. Nobody need question that. Nobody can say that we are not being regarded as, we were not saying that we are not an integral part of India.
Article 1 applies.
Article 1 applies. And the Constitution defined that relationship. And having defined that relationship, you can't just jettison it. Section 5 of the Constitution of Jammu and Kashmir provided that the legislative power of the state extended to all matters except those with respect to which Parliament had power to make laws for the state under the Constitution of India as applicable. Applicable to the state of Jammu and Kashmir. Legislative powers in the state were to lie with the Legislative Assembly and the Legislative Council. Significantly, Section 147, which dealt with amendments to the Constitution of Jammu and Kashmir, provided that no bill or amendment seeking to change the provisions of the Constitution of India as they applied to Jammu and Kashmir would be introduced or moved in either of the state legislatures. They had no authority once the Constitution had come into force and the orders passed. Then on 21/11/1964, the Constitution application to Jammu Kashmir Third Amendment Order of 1964, that is CO 71, which amended the 54 order, made Article 356 applicable to the state with one modification, that the expression included the Constitution, excluded the Constitution of Jammu and Kashmir. Included, yes, included the Constitution of Jammu and Kashmir.
Those are there in all which have been passed.
I'll have a list.
You can just give the list.
Volume 3, you have all the orders.
This, you have now made your point on this. So all the orders.
I'm not asking your lordship to go through. I'm not even going to read it, Manas. Yeah. Yeah. We're not going to go into all this.
54, about 54 orders.
54 orders are there, around 54 orders.
Of the.
Yes.
The legislative.
Of course, of the assembly.
No, some government.
Section,
The government, Manas.
under D or under?
D1.
Not, no, B2 or B2 or B1, D.
D2, Manas.
D2.
D1, D1.
The D only has one,
just D,
the
Madam.
proviso.
It's just D.
D. D
Yeah.
doesn't have a number 2 or.
And most of them are amendments of the 54 order, Malaj. 50 order, 54 order, and then amendments to the 54 order. That's what it is. Yeah, but is it necessary? My lord is saying that out. Item 43.
Yes.
The Lordships don't mind, it's PDF 44. The Kashmir Accord, now that's a political document. (1975) was entered into, my lords have it. PDF 44. The Kashmir Accord 75 was entered into between the Government of India and the Government of Jammu and Kashmir. Under Clause 1 of the Accord, the relationship of the state of Jammu and Kashmir with the Union was to continue to be governed by Article 370 of the Constitution. Now, kindly note, Malaj, the temporary provision was over. Still be governed.
Why was this required to say it is to be governed if it is a permanent feature?
Sorry?
Why was there a requirement 27 to say this will continue to govern when it was a permanent feature?
Malaj, it also reiterated the residuary powers of the state. Malaj, that's not the only thing that happened. It's just a reiteration of the position that was accepted by the Government of India throughout, which is the constitutional position. After all, it's a political accord, Malaj. I mean, it has no legal basis that way, but it tells you of the intent of the signatories, Malaj.
Political change at that time.
Yes, I know that. Malaj, in any case, 75 is a momentous time in the history of this country. Yes. Luckily, I was out of the country, Malaj, so I.
The response to the Sheikh Abdullah settlement.
Yes. So, fine. Huh? in jail for ultimately 14 years. The background is, Malas, that whenever he came out, he was saying that, no, no, give us autonomy, give us autonomy. It is in that context that the accord was there, that you can't get out of 370. That's really the background to it. He was put in jail even by Mrs. Gandhi. So, Malas, the rest of the list of dates. Kindly now see, come to straight to PDF 47. On 29th of March 2017. Then, of course, the clamoring began, remove 370, do away with 370. But that's a separate issue. I mean, we're not concerned with that. So
You are on 55 now?
55, exactly, man. Well, Lord Justice Khanna has 55. Justice Gawai. That's Suryakant. Yes. Member of Parliament Ratna Dinag raised a question whether the Minister of Law and Justice, as to whether the government proposes to amend and remove 370 related to Jammu and Kashmir in the near future. If so, details thereof, if not the reason therefore, whether this will help in providing equitable justice to the people of the state, and if so, the details thereof. Minister of State and Law and Justice, so and so. At present, there is no such proposal under consideration.
These are only proposals.
These are only proposals, all no throughout. It goes on, Malik.
Yes.
Then 57 is Malad's section 92. This is important. Item 57. Section 92 of the Constitution of Jammu and Kashmir deals with provisions in case of a failure of the constitutional machinery in the state. Provision permitted the governor to, by proclamation, assume to himself all the powers and functions of the government of the state. Such a proclamation would, in terms of 92(5), require the concurrence of the President of India. Under 1923, would cease to operate 6 months after it was issued. On June 20, 2018, the governor, with the concurrence of the President, issued a proclamation under 92, declaring governor's rule in the state. This is important. Now we're coming to the present controversy. We can do it tomorrow, Madam.
We can then continue tomorrow.
Deeply obliged.
Oops.
हर व्यक्ति अपने आप में एक योगी बन सकता है अपने कर्मों से।